International Moot Court Competition on Climate Justice and Environmental Governance. I'm your host, Wanjera Maganjo. And before we begin the formal program, I just want to say thank you for joining us. I would love us to take a virtual photo, a group photo. So may I kindly request that all our judges, all our distinguished speakers, team representatives, and the general audience to turn on your cameras for a quick, brief group photo. So kindly everyone, I will start with our CEO, Mr. Brian Wanda. Please turn on your cameras for a group photo. Thank you so much, Lady Justice. Helen, for joining this conversation. Everyone, please thank you so much to everyone. All right, at this point, I'm gonna ask our IT team lead, Simon, to talk to us and tell us when we are all on camera and when everyone is set up and he can take the group photo. So Simon, over to you.
Thanks a lot. My name is Simon Wekesa. I'll be waiting for all of you to turn on your cameras. Then we have 3 pages of attendance, so I'll check the photos. First of all, I start with the first page. When I've taken, I'll let you know. Kindly, all of us, let us open the cameras. We're still waiting for Naomi, Daniel, and Denzel. Kindly. 3 more seconds for all of you to open the cameras. Okay, in 1, 2, 3, I'll take the first. All right, hold on, I go to the next page. All right. Hold on, I'll take in 1, 2, 3. All right, thanks a lot, that's all.
All right, thank you so much, Simon. And thank you to every one of you for adhering to that. And perfect. This is a great way to start to see all your faces. So at least I know that I'm not alone on this conversation. So thank you so much. You may turn off your cameras if you so wish. All right, so thank you so much. Like I said earlier, on behalf of the Green Law Global Initiative, we welcome you into this 2026 International Moot Court Competition. And this distinguished gathering brings together emerging legal minds, esteemed members of the bench, academia, and leading institutions shaping the future of environmental law. So let me set the setting a bit. So this year's Moot is uniquely positioned at the intersection of some of the most pressing global challenges, including climate change, transboundary environmental harm, and the circular economy. So structured in the style of an international court of justice, this competition invites participants to deeply engage with evolving questions of environmental governance and international responsibility. With that said, we are really privileged to be guided by the distinguished bench comprising of members of the judiciary, senior counsel, and leading practitioners and scholars in the environmental law. Their presence ensures that this competition reflects not only academic rigor, but also real-world legal practice and judicial reasoning. So now, we will now proceed into the official opening remarks. Kindly note that each speaker will have a brief allocated time, and I will gently guide transitions to ensure that we remain within schedule. And without further ado, it is my great honor to invite the CEO of the Green Law Global Initiative to deliver his remarks. And kindly note, Brian, you have 5 minutes. Let's give it up for Brian Awanda, who's the CEO of the GLGI initiative. Karibu sana, Brian.
Thank you so much. As you've been told, my name is Brian Awanda. I'd like to welcome you to this 2026 flagship Green Law Global Initiative International Moot Court Competition on Climate Justice and Environmental Governance. Good afternoon, morning, evening, distinguished guests from around the world, esteemed speakers, participants, colleagues, and friends joining us from across the world. On behalf of the Green Law Global Initiative, it is truly a pleasure and an honor to welcome you to the 2026 GLGI International Moot Court Competition. The Green Law Global Initiative is a mission-driven environmental law platform dedicated to strengthening ecological governance through legal systems. Our work is grounded in the principle that environmental sustainability must be supported by enforceable rights. Our work is grounded in the principle that environmental sustainability must be supported by enforceable rights, accountable institutions, and well-trained legal professionals capable of advancing climate and biodiversity justice within courts and policy spaces. This competition is part of that vision. GLGI operates across 4 core pillars. First, strategic environmental litigation, where we conduct legal research, develop litigation strategies, and support cases that advance constitutional environmental rights, climate accountability, biodiversity protection, and corporate responsibility. Our approach emphasizes long-term jurisprudential impact rather than isolated legal victories. Second, policy and legislative reform. We engage in drafting model environmental laws, contributing to regulatory reform discussions, and developing governance frameworks that align domestic environmental law with international environmental obligations. Third, our capacity building and legal education, where we train emerging environmental lawyers, public interest advocates, and law students through international moot court competitions to engage effectively with climate litigation, environmental rights enforcement, and national environmental disputes. Fourth, climate justice and intergenerational equity advocacy. We promote legal doctrines that recognize the rights of future generations, strengthen public trust principles, and advance human rights-based climate litigation. A central component of Green Law Initiative's institutional mission is the International Environmental and Climate Justice Moot Court Program. This initiative is designed not as a purely academic exercise, but as a structural intervention into the future of environmental jurisprudence. The Moot Court simulates complex transnational environmental disputes involving issues such as the International Court of Justice, advisory opinion on state responsibility in matters climate change, transboundary textile harm, circular economy principles, state responsibility for climate inaction, corporate liability for environmental harm, constitutional environmental rights enforcement, and where participants engage with comparative constitutional law, international environmental treaties, climate finance mechanisms, corporate accountability doctrines, and human rights-based environmental claims. The program serves 3 strategic purposes: builds litigation competence among future environmental lawyers, creates a global network of legally trained environmental advocates, cultivates jurisprudential thinking that anticipates the evolving landscape of climate biodiversity. Over the coming weeks, we will engage with complex and evolving questions at the heart of international environmental law, questions around climate responsibility, transboundary harm, and access to justice. But beyond the problem itself, this moot is about cultivating precision in legal reasoning, clarity in advocacy, and a deep appreciation for the role of law in shaping our collective future. What we are building through GLGI goes beyond a single competition. With the guidance of our International Academic Advisory Board, comprising leading scholars and practitioners in environmental law, we are steadily laying the foundation for a global platform that connects legal education, practice, and policy in service of climate justice. Moreover, through this initiative, such as the Rosemary Ayugi Memorial Award for Climate Justice Leadership, which is the highest honor presented at the GLGI International Moot Court Competition, we honor principled leadership and reaffirm that law, when properly stewarded, remains one of the most powerful instruments for safeguarding human dignity and ecological integrity. To our distinguished judges, we are deeply grateful for your time and your commitment to mentoring the next generation through this process. Your presence gives this platform both credibility and meaning. To our participants, you are the center of this initiative. You are not just competing, you are stepping into a space that demands thoughtfulness, rigor, and principle. The future of environmental law will in many ways be shaped by voices like yours. At this juncture, with deep humility and gratitude, I would like to recognize the 2026 GLGI participating teams. 1, Lincoln Alexander School of Law, Toronto Metropolitan University, Canada. Mentors and Moot, South Africa. Lead City University, Nigeria. Great Zimbabwe University, Herbert Chitepo Law School, Zimbabwe. University of Zimbabwe, Africa Nazarene University, Jomo Kenyatta University of Agriculture and Technology, Kisii University, Chuka University, Egerton University, Uma University, Catholic University of Eastern Africa. We also wish to sincerely acknowledge the knowledge partnership of the United Nations Environment Programme and the technical support of C4 ICRAF, World Agroforestry, and our dedicated IT team led by Simon Wekesa, whose contributions have helped ground this competition in both substance and structure. As we begin today, we do so with intention, not simply to run a competition, but to advance a conversation, to strengthen a discipline, and to affirm that law remains one of the most powerful tools we have in confronting environmental justice. And so with that, it is my distinct privilege to declare the Green Law Global Initiative 2026 International Moot Court Competition officially open and to invite each of you to rise to the standard that this moment demands. Thank you for your interest in this important work. Thank you. Back to you, Angela.
Thank you so much. Let's give him a round of applause. Thank you so much, Brian, for bringing this conversation to the table, and we appreciate it. So we appreciate all your wonderful remarks. At this particular time, it is my distinct honor to invite our keynote speaker, and this address will help frame the broader global context within which the Moot is situated, particularly in relation to environmental governance and the rule of law. I now invite Professor Patricia Mbote, the Director, Law Division, UNEP.
It is a real pleasure to deliver this keynote, and I want to begin by acknowledging you, the participants. Moot court competitions of this kind are not peripheral to the development of international environmental law. They are part of it. The arguments you construct, the principles you interrogate, and the positions you defend will sharpen the thinking of the next generation of lawyers working on exactly these issues. Moot court competitions occupy a unique space in legal education. They ask you to do something that textbooks cannot fully prepare you for, to construct a coherent legal argument under pressure, defend it against scrutiny, and engage seriously with the other side. In the field of international environmental law, where so much is still being interpreted, contested, and developed, that skill is essential. The lawyers who will shape climate jurisprudence over the next 2 decades are in virtual rooms like this one today. The rigor you bring to this problem, the quality of your reasoning, and the creativity of your arguments genuinely matters. The world you're being trained to serve is facing a profound crisis. The climate is becoming increasingly unstable. Global warming is projected to reach approximately 2.8 degrees Celsius above the pre-industrial level by the end of this century. And even if every country fully implements its nationally determined contributions, temperatures are still expected to rise between 2.3 and 2.5 degrees. So quite clearly, we are off track. We already know that climate change has a tremendous impact on human rights, humanitarian needs, welfare, and dignity, particularly for those in vulnerable and marginalized situations. In many ways, it is rocking the foundations of peace and security. Consider Africa for a moment. The continent emits less than 5% of global greenhouse gases, yet it carries a disproportionately heavy burden because of its high vulnerability and limited adaptive capacity. Climate variability is already negatively impacting the health of tens of millions of Africans, exposing them to extreme weather and the spread of infectious diseases. And looking ahead, by 2030, around 118 million of the continent's poorest people could be further exposed to droughts, floods, and extreme heat. That is, if we do not design and put adequate responses in place. Anchoring solutions in law is critical. We need to advance the environmental rule of law. And this is where law comes in. Strengthening environmental governance is one of the most effective tools we have to tackle this crisis. But it's not just about having policies on paper. It demands effective institutions, credible enforcement, and real accountability mechanism. And this is where the environmental rule of law becomes significant. It is the foundation for translating environmental rights and obligations into actual action. Without it, even the most ambitious laws and policies risk remaining symbiotic rather than driving the systemic change we need. UNEP's Environmental Rule of Law report makes this gap very clear. Over 176 countries have environmental framework legislations in place, but implementation and enforcement continue to be the weakest link. So it is not just the absence of laws that is the problem. It is how effectively they are being applied and enforced. Robust legal and policy frameworks provide predictability. They safeguard rights. They create fair conditions for decision-making, enable participatory governance, and ensure that environmental protection is not sidelined by political expediency or short-term economic pressures. UNEP supports this work through its Montevideo Environmental Law Program, providing technical legal assistance, capacity building for legal professionals, and research on emerging areas of environmental law. It is work that connects directly to what you're doing in this competition. Courts are indeed agents of climate justice and accountability. And I'd now like to turn to courts. Across the world, citizens, communities, and increasingly corporations are turning to courts. Courts are becoming a critical avenue for securing accountability, safeguarding rights, and compelling action, especially when other routes fall short. UNEP has been tracking this trend in climate litigation since 2017, and the numbers tell a clear story. Between 2017 and 2025, the number of climate litigation cases has gone from 884 to 3,000, with a notable rise in cases originating from the Global South. Cases from the Global North are also shaping the conversations in important ways. The Klima Signorinen case before the European Court of Human Rights, where state inaction was recognized as a violation of rights, Germany's Nuremberg decision, which mandated emissions reductions to safeguard future generations, and more recently, the Lua case, which pushed the question of corporate liability for greenhouse gas emissions. Together, these cases are re-envisioning how we think about climate justice. This is also reflected in UNEP's recent work on the right to a healthy environment. In its analysis of trends across a decade from 2015 to 2025, UNEP found that courts are increasingly reaffirming the centrality of the climate system to the recognition and sustenance of this right. Now, only around 2.1% of climate litigation cases recorded have been filed in African courts. But this does not mean that issues of justice are not at play. Civil society organizations continue to challenge the construction of the East African crude oil pipeline on the grounds that it was built without proper environmental, social, human rights, or climate impact assessments. And climate cases are increasingly no longer confined within national boundaries. They are constructing transnational narratives, which is exactly where this moot court competition becomes significant. This includes the landmark advisory opinions from the International Court of Justice, the International Tribunal for the Law of the Sea, and the Inter-American Court of Human Rights. And we are still awaiting the opinion of the African Court on Human and People's Rights. The ICJ advisory opinion delivered in July 2025 is particularly significant. It clarified that states have legal obligations to both mitigate and adapt to climate change, grounded not only in climate treaties, but also in customary international law and human rights law. And importantly, it extends responsibility to the actions of private actors within a state's jurisdiction. When you take this together with the opinions from ITLOS and the Inter-American Court, we now have a much clearer and more authoritative interpretation of the legal framework available to address climate change. These developments are expanding the legal foundations for climate action, deepening accountability, and strengthening the role of international law in responding to these crises. Which brings me to why the problem you have been given matters. Though fictional, the Moot problem raises very real issues. Around 92 million tons of textile waste is generated globally. This is equivalent to a truckload of clothing being dumped or burned every single second. And a large proportion of this waste does not stay where it is produced. It is exported to countries whose waste management systems are ill-equipped to handle it. What you see in this Moot problem is not hypothetical. It captures exactly where international environmental law is today. You're being asked to deliberate on an increasingly urgent question. What are the legal obligations of states when harm is caused through global value chains, in this case, textile and apparel waste? And that takes us directly back to the ICJ advisory opinion, because what the ICJ clarified is that states cannot look away from harm, even when it is driven by private actors. That is exactly what this Moot problem is testing. So when you engage with circular economy approaches, reuse, recycling, extended producer responsibility, remember that these are not just policy preferences, they are legal necessities. And crucially, what you are engaging with in this Moot is not a settled area of law. It is an evolving space, which not only makes the challenge more interesting, it means the next generation of lawyers, your generation, has a genuine contribution to make to a larger dialogue on solutions. The arguments you develop here, be they on due diligence, on transboundary harm, on circular economy obligations, are exactly the kinds of arguments beginning to appear in real courts and real disputes. So treat this problem as more than a moot competition. See it as an opportunity to engage seriously with one of the most pressing legal challenges of our time. Be creative in how you think about responsibility and how you interpret existing principles. Stay grounded in both law and justice, and think about how they can be reimagined to drive the systemic change our planet needs. I wish you all the very best.
Thank you very much for that powerful and thought-provoking keynote. We are truly honored. Let's give a round of applause. Thank you so much. Kindly, please, this is courtesy call to everyone in the house. Please ensure that your microphones are muted and that your video is on where possible. So kindly let's look into that. It is now my honor to invite Lady Justice Helen Omondi, Court of Appeal President, International Association of Women Judges, and GLGI Presiding Judge, to give their opening remarks. Welcome.
Thank you. Thank you very much indeed, and greetings to all present in this session. It is indeed an honor to be part of this Green Law Global Initiative International Moot Court Competition 2026 and interact with great legal minds on a subject which is no longer a preserve of environmentalists, civil society, and public interest litigants. As early as 1968, the UN on 3rd of December 1968, the UN General Assembly in its resolution noted in particular the continuing and accelerating impairment of the quality of human environment caused by various factors and expressed concern about the consequent effects on the condition of man, his physical, mental, and social well-being, dignity, and enjoyment of basic human rights. The global climate patterns are changing so rapidly and with such unpredictability that it is now a lived reality affecting all creation, the humans, animals in the wild, sea life, and those in the air. With it comes the increasing threats to fundamental human rights, including access to water, food, shelter, and health. The emerging trends globally is that there is a marked rise in the volume and diversity of cases up for this litigation in relation to climate change. We are now witnessing a shift from policy review to performance assessment. Courts are being called upon to interpret constitutional and international obligations in new ways that require thorough research, structured analysis, and evaluation of legal provisions and the lived reality and the demand for sustainable development. I think the best place to begin is an interaction of legal minds who fuse the academic research approach with the legal practice. What better way to embrace an immediate and urgent response, examining the well-being of present and future generations of humankind? Courts find themselves being called upon to state what are the obligations of the duty bearers and to reaffirm the rights of those affected by breaches. Climate litigation has emerged as a tool to challenge inadequate action on climate change, both by public institutions and private entities. Globally, diverse legal approaches are being used to push for stronger mitigation and adaptation efforts, though in some cases, litigation is also used to resist or weaken existing climate policies. We already possess the doctrinal tools which set out rights, statutes which set out duties, international instruments which espouse the principle of prevention of significant harm to the environment, and the duty to protect and preserve. To my fellow judges, the issue that looms in environmental rule of law and enforceability is what drives compliance or non-compliance. The concern is the need to reconcile economic development with the protection of the environment. Are courts, for instance, consistent in their pronouncements? Do the decisions reflect courage in applying the law as it is and as it ought to be in a bid to ensure justice, equity, and resilience? I say this because judiciary's proactive stance can transform climate governance and climate governance from aspiration to enforceable reality. And to Dr. Brian, I wonder, universities are meant to prepare solutions to address the climate shocks, take up research that will influence policy. Well done for taking the initiative and pursuing a collaboration with organizations that implement and enforce. I truly hope that climate change will form a foundational course in every academic curriculum in the institutions globally. To the participating teams, a thumbs. I wish each one of you the best. Thank you so much for your attention.
Thank you so much, Lady Justice Helen Omondi from Court of Appeal. We appreciate it and thank you so much for the wonderful remarks. It is now my honor to invite Sydney Netaya for Dr. Philip Osano, the Chief Operating Officer for CIFOR and ICRAF World Agroforestry. You have 5 minutes. Kindly proceed.
Thank you so much, Wanjira. And thank you again to Brian and the team for this invitation to be part of this conversation. Maybe to spice up things a little bit, I am neither a professor, a justice, nor a doctor, but I stand in to represent Dr. Philip Osano, who because of last-minute scheduling conflicts could not attend this session. And in which case I will say a few things about the conversations we are having with Philip, with Dr. Osano, as well as the conversations they're having with the CEO of GLGI, Brian. So to begin with, my name is Sydney Tambasi Netia. My latest qualification being an LLM in international law from the Geneva Graduate Institute, and I'm currently working at C4ICRAF as a science diplomacy consultant. Part of the work we are doing with Philip at the moment is we are organizing an African States Sensitization Conference in response to the ICJ advisory opinion, which has been on climate change, which has been referenced to by previous speakers. And part of what we are doing is we are bringing in member states from Africa, specifically IGAD and EAC member states, to talk about specific aspects of the advisory opinion and how this affects their day-to-day in terms of their obligations, in terms of what is expected to them, and not just member states, but other stakeholders, for instance, the private sector, for instance, civil society, and we are talking about, issues such as loss and damage, climate finance, and many other issues that are related to the advisory opinion. I know Brian already has a relationship with Dr. Osano, and they've been talking about conversations specifically with the forestry research, and that is a species-specific tree-level carbon census. Now, this, of course, is extremely necessary to enhance the efficiency of Kenya in calculating the carbon in Kenya's forest reserves. Now, this will enable us to move from a position of estimates in terms of calculating carbon credits to greater efficiency, which now translates to revenue generation and which the country can tap into for greater fiscal responsibility and efficiency. Specifically for this Moot, having done Moots myself and been a product of Moot courts during my undergraduate days at Kenyatta University, I know that it is one of the most efficient avenues for legal training because it combines nearly all the skill sets that you need to be a good lawyer. And I have many seniors on the call who might confirm this, and their commitment is testament to this as well, because you have research combined with oral advocacy, with also shorter feedback loops that support in terms of greater efficiency, in terms of your all-roundedness as a lawyer. And for this specific subject, the idea of law as a tool to combat issues such as environmental degradation is something that, as we would say, we take judicial notice of. Finally, I would just encourage the Moot participants or the competitors that sometimes there is a lot of pressure when you go into these kinds of setups and you've prepared for months, sometimes a lot of team engagement, a lot of feedback loops. But I would say just have fun. Try have fun during the competition. You are the subject matter expert on the Moot question. Of course, you have judges and other international, climate change, environmental law experts. But with respect to the Moot question and the subject matter, you are the subject matter experts, and guide the judges, help them understand better your points of argument and your points of view. And very finally, make sure you make friends for the future, because it is through such forums that you engage in networks and you get to build your communities. Thank you very much. Once again, I pass the highest regards of Dr. Osano, and I wish you all the very best as we continue with the program and the competition in the coming days and months. Thank you so much.
Thank you so much, Sydney, and we appreciate it, and we wish Dr. Philip Osano all the best wherever he is. Thank you so much for coming on his behalf. At this particular juncture, I would want to give an appreciation to every one of you who's joining us, and thank you so much for taking your time to be in this meeting. Right now, I'm going to invite retired Justice Mkule, GLGI resident judge, and sir, you have 2 minutes.
Communication from Justice Mkule is setting up, so you can go to the next first.
All right, as we're waiting for Honorable Justice Matthew to come on board, I would love to invite Professor, I hope I pronounce your name right, Professor Anje Wild from HNU University, Germany, GLGI Academic Advisory Board member, Welcome. You have 3 minutes for your remarks. Welcome.
I don't see her on the platform. Maybe we could just proceed. When she comes, she can pick up where we are.
All right. So thank you so much for that, Brian. At this time, I would love to welcome Professor Steven Steck, the Central European University, University of Baltimore of Law, GLGI Academic Advisory Board member, to give us his opening remarks for this event today. Welcome.
And welcome. I'm coming to you from the Moot courtroom of the University of Baltimore School of Law. I bring greetings from the Center for International and Comparative Law here, and also from my home institution of Central European University. I'm genuinely glad to be able to speak to you at the opening of the 2026 Green Law Global Initiative International Moot Court Competition. I want to commend the organizers, including my friend Brian Awonda, for bringing together 12 excellent teams from all over Africa and even from as far away as Canada. And to the professors, supervisors, and coaches who guided these teams here, thank you for inspiring your students to examine hard questions with their strong legal minds, and maybe for pushing them a little too. But most of all, I would like to address the student advocates. You put in the hours, studied the law, wrestled with the arguments, and now you are prepared to defend your position against your opponent vigorously so that it will be the best law and the best positions that prevail. You've worked hard to get here and have already accomplished everything you need to. Now the fun begins. But in all seriousness, I want to commend you for taking up the challenge of the most pressing questions that are facing international law and, I say it truthfully, global humanity. I suppose that most of you are here because you are concerned about the environmental challenges facing our planet. Climate change, biodiversity loss, pollution, and the impacts on communities that are on the front lines of ecological collapse. These are the challenges that define the times we live in. Roscoe Pound has said, law is the most powerful instrument of social change. Many of you may intend to spend your careers together with others around the world who are using the law to find solutions and to find justice. Gradually, people all over the globe are becoming aware of the profound effect that environmental challenges have on our current state of divisiveness and polarization. It is now a commonplace to say that the environment crosses borders, that it doesn't belong to any party, ideology, or interest group. Clean air, clean water, a stable climate, these are the shared inheritance of every person on earth, regardless of where they were born, how they vote, or what they believe. But what we are only starting to be aware of is that what we are seeing sweep over the world today, the sorting into political tribes, the anxiety over who will still be standing when the social conflict ends, the high temperature in our everyday interactions, can be lowered if we bring down the temperature of the globe, if we face and solve these challenges of our times. And it is the law at its best where that reality can be acknowledged and where rule-based solutions can be found. That is the space you are stepping into. You are on the front lines, and this is your training. So take a breath, look around at your neighbors and your teammates, know that what you are doing is important, but also trust in what you've done up to now, do your best, compete hard, and have fun. Good luck to every team. I'm looking forward to the competition. Thanks for your attention.
Thank you so much, Professor Steven Steck from the Central European University, University of Baltimore. We appreciate the wonderful remarks. At this particular time, we're going to go back into retired Justice Matthew Makule, who is the presiding judge of GLGI here at Nairobi. Welcome, sir. You have 2 minutes.
Good afternoon, everyone. It's my pleasure to...
Judge, we can't see you. We can only see your wig.
Oh,
Just tilt your camera a bit.
I think you just adjust your camera. Your camera must be pointing to the roof. Maybe you just adjust it a bit.
Oh, is that better?
Now we've lost you completely, almost. Adjust again, please. No.
Any better?
We've lost you completely now.
Do I stand?
Please do, yeah.
Can you see me?
Yeah, I can see you now.
Good. It's my pleasure to welcome all of us to this moot court. It has been a long journey. I commend Brian for his dedication and brilliance towards developing what we called Green Law Africa, now into Green Law Global Initiative. And congrats, Brian. For my fellow judges, welcome to development of green law so that we can help in a small way in mitigating the effects of climate change. Climate change is for real. If you remember our old case of Republic against, we're against the Republic, it takes a lot of effort by the judiciary to lead the way in developing enforceable rulings and orders so that ultimately the people we say we serve will be served. In the Oweru case, remember, the petitioner had been actually charged in court for allegedly polluting a river in Ngong. Court went behind and found out actually the evidence was that the local authority had done absolutely nothing towards helping the local shopkeepers in developing rural homes, etc. So following that judgment, a whole project that covered the entire urban area of Ngong was developed by the late Professor Saitoti, who was then MP and Vice President of the Republic of Kenya. So that's the effect of effective litigation towards helping socio-economic development. Fellow participants, you are the leaders and advisors of governments as well as large corporations tomorrow. It is your duty to imbibe the law on climate change towards realizable solutions for the prevention or at least mitigation of the major areas like degradation leading to desertification, development of clean water and a healthy environment for all the people. So welcome to this moot court, and I wish the very best, my fellow judges, esteemed participants. Thank you very much for listening to me.
Thank you so much, Your Honor, retired Justice Matthew Mkule, who is a resident judge of GLGI. So thank you so much for those wonderful remarks. Right about now, we're about to conclude on these remarks. We welcome Veronica Humphrey, the Master Circularity and Sustainable Fashion, HNU University from Germany. Over to you, Veronica. You have 2 minutes for your remarks.
Hi, thank you very much for having me here today. But I come to you not as a lawyer. I come to you as someone who has spent countless hours making, designing, and thinking about clothes, thinking about where they go and what they cost the planet long after someone stops wearing them. I studied apparel design and environmental sciences and then pursued a master's in social entrepreneurship for sustainable development because I became convinced that the most urgent sustainability challenges cannot be solved by any single discipline alone. Not by designers, not by scientists, and not with respect by lawyers alone either. And I'll be honest with you, when I first encountered the legal frameworks you'll be arguing this week, I was struck by something important. The clothes in this case are not hypothetical. They are real. The millions of tons of secondhand clothing exported each year to the global south from the global north. The Continental market in Accra, the Gikomba market in Nairobi, to the dump site fires, to the microplastics washing into the Indian Ocean. These systems are not abstractions, they are someone's livelihood and someone else's burden as well. What makes this Moot extraordinary is that it places exactly that tension before you. The circular economy is both a solution and a site of injustice. Secondhand apparel sustains millions of people across the global south. It also, when mismanaged, poisons their coastlines and clogs their drainage systems. What I want to leave you with is this. The law catches up slowly. Science, design, and business models are already reshaping how we think about material flows, producer responsibility, and the life cycle of a garment. However, the ECJ's 2025 advisory opinion on climate change is a landmark moment because it signals that international law is trying to catch up to. Your job this week is to help write what catching up actually looks like, in doctrine, in argument, and in remedy. You're future lawyers, but this issue you'll be arguing traceability, extended producer responsibility, transboundary harm, and intergenerational equity. These are not purely legal questions. They are design questions, supply chain questions. They're questions of justice that cut across every discipline. So argue well, push each other, and remember, the communities most affected by textile waste did not create the system that harms them. Your arguments for this week are, in a very real sense, for them. I wish you all the best of luck, and thank you all for your time and commitment to these issues.
Thank you so much, Veronica Humphreys, and we appreciate your wonderful remarks, very thought-provoking. Right about now, I'm going to invite Denzel Munga, the agricultural consultant, proprietor, Savannah Propagators Nurseries, and climate litigation petitioner. Over to you, Denzel Munga. You have 2 minutes. Please unmute. We cannot hear you.
We can't hear you. Maybe you log out, you log in again.
All right, as we're waiting for Denzel Munge to come in, we'd really want to appreciate every one of you for being part of this conversation today. We're looking forward to a wonderful conversation on matters to do with climate change, circular economic, and transboundary apparel harm. So thank you so much. I think Munge is back, so over to you, Munge. You may want to check your microphone. I still cannot hear you. I don't know, as we're waiting for him to come back, maybe Brian, you can give us a few highlights from what you've taken out from the keynote speakers and some of the remarks as we're waiting for Munge.
Thank you very much for all the speakers thus far. Participants, you've heard from our keynote speaker, Professor Patricia Mbote, where she says environmental rule of law is the tool that we need to use now to combat this climate crisis. You've also heard from Lady Justice Ellen Omondi, and I shared with you participants the judgment that Honorable retired Justice Matthew Mukule has just talked about, Waweru versus Republic. I know you've gotten a chance to interrogate it. It was not a long judgment. I believe as we wait for Denzel Munge, I can go ahead with the program and introduce the judicial bench, because that was what was to happen next. Or Denzel, you're back?
Confirm if it's working.
Good, good. You can hear you now. Proceed.
All right. Thank you, Green Law Africa, for the opportunity to join this important 2026 Moot. Today, we reflect on a growing environmental concern that is often overlooked, the impact of waste clothing on environment, and how we can turn this challenge into an opportunity, especially within agriculture. Globally, fast fashion has led to a surge in textile waste. Millions of tons of clothing are discarded every year, much of it ending up in landfills where it takes years to decompose, releasing harmful substances into our soils and water. Even locally, we see the impact blocked drainage systems, polluted landscapes, and rising pressure on waste management. But within these challenges lies an opportunity, particularly for farmers. Farmers can reuse old clothing in practical ways, as much as mulch to conserve moisture, suppress weeds, as plant ties for crops like tomatoes, beans, as bird deterrents to protect crops, as scarecrows, and as cleaning materials for farm tools. However, these challenges, some fabrics, especially synthetic ones, are not biodegradable. Awareness on safe reuse is limited, and systems for collection and sorting remain underdeveloped. Despite this, the benefits are clear: reduced pollution, lower farming costs, more sustainable farming practices, and new opportunities for community recycling initiatives. This is not just waste management, it is about practical sustainability at farm level. As we conclude, let me connect this to a broader effort to protect farmers. As an agricultural consultant and a petitioner in landmark case in Kenya, I'm part of the movement demanding accountability. Farmers have taken the government of Kenya to court, including the president and the key state agencies, for failing to act on climate change, despite obligations under the Paris Agreement and national laws. Led by retired Justice Matthew Amekule and argued by Dr. Brian Awanda, the case is awaiting judgment in June 2026. This case matters because of what it can deliver for farmers. If successful, it will push for real enforceable actions, including stronger climate support systems, investment in adaptation like irrigation and soil conservation, and inclusion of farmers in decision-making. It ensures farmers are not left to face climate risks alone. From reusing old clothing on our farms to demanding accountability at the highest level, every action counts. Let us act locally while pushing for change globally. Thank you very much. And I'm really happy for the Moot Court and wishing you all the best. Thank you.
Thank you so much, Denzel Munga, the agricultural consultant and proprietor of Savannah Propagators Nurseries and climate litigation partner. We appreciate your wonderful remarks, and we look forward to also hearing what the participants are going to be sharing with us. Right about now, I'm going to call back Brian Awanda, who's the CEO of Green Initiative Global Initiative Africa, to give us his remarks as well and introduce the judicial bench.
Thank you so much once again to be here. Thank you, Angela, for the moderation. Thank you for the judges and the distinguished speakers for your very key comments, which come at a timely time, at such a pressing time as this. So I take this opportunity to introduce the judicial bench. Lady Justice Helen Omondi has just spoken. She's the judge of Court of Appeal of Kenya. She is also the president of the International Association of Women Judges. She has worked for over 22 years as a magistrate, demonstrated exceptional judicial leadership. She progressed from the rank of Chief Magistrate in 2003 before her elevation to the High Court in 2007. Her appointment to the Court of Appeal reflects her distinguished record of legal reasoning, impartial adjudication, and fidelity to constitutional principles. She holds a master's degree in women's law from the University of Zimbabwe. We thank at least they're here. A Bachelor of Laws from the University of Nairobi, and a Diploma of Law from the Kenya School of Law. She also earned a certificate in graduate study and professional development from the University of Minnesota, underscoring her commitment to continuous professional excellence. Her leadership extends beyond the courtroom. As we have said, she currently serves as the president of the International Association of Women Judges, a prominent judicial association dedicated to promoting gender justice, human rights, and mentorship within the judiciary and the wider legal profession. As a judge for the Green Law Global Initiative, Justice Omondi brings a rare combination of appellate experience, mentorship ethos, and principled legal leadership. Her participation enriches the academic rigor, strengthens its adjudicative integrity, and provides young advocates with an extraordinary opportunity to be guided by one of Africa's most accomplished jurists. Her leadership resonates deeply with GLGI's mission to cultivate high-caliber climate justice advocates, advance environmental governance discourse, and inspire the next generation of legal minds committed to serving the public. And Justice Helen Omondi is our presiding judge for the 2026 GLGI International Moot Court competitions. Then we have Justice retired Matthew Amekule, EBS. a distinguished retired jurist and a senior advocate of the High Court of Kenya, whose long and impactful judicial career has left a lasting mark on the Kenyan legal landscape. Over the course of his tenure on the bench, he presided over numerous consequential matters that shaped legal doctrine and strengthened the rule of law. His judgments were marked by analytical rigor, clarity of reasoning, and a deep appreciation of the evolving role of courts in safeguarding public interest. Justice Omukule is notably associated with Kenya's environmental jurisprudence, having been part of the bench in the case he just said, Peter Waweru versus Republic, a locus classicus in environmental law. The decision engaged foundational principles such as sustainable development, precautionary principle, intergenerational equity, and the integration of international environmental norms. Throughout his judicial service, Justice Omukule earned recognition for his independence of thought and his unwavering commitment to procedural fairness. His courtroom was characterized by disciplined adjudication, respect for counsel, and a steadfast insistence on integrity of the judicial process. Beyond the bench, he has continued to contribute to legal education and mentorship, sharing his experience with younger members of the profession and supporting initiatives that strengthen environmental rule of law. As the founding presiding judge of GLGI, Justice Omukule brings to the platform not only judicial authority, but also a generational perspective on the evolution of environmental justice in Kenya and beyond. His participation in GLGI reflects a long life commitment to nurturing principled legal leadership and ensuring that the next generation of advocates are equipped to confront complex legal questions of climate governance and environmental law. Then we have our third judge, Senior Counsel Eric Theuri, a personal friend. Senior Counsel Eric Theuri is a distinguished Kenyan advocate and a leader in the legal profession with over 2 decades of experience in litigation, dispute resolution, and corporate legal practice. He served as the 50th president of the Law Society of Kenya from 2022 to 2024, bringing robust advocacy for judicial independence, ethical practice, and legal professionalism to the forefront of the profession. Admitted to the bar as an advocate of the High Court in 2005, Eric Theuri is the managing partner and head of litigation and dispute resolution at Theuri Wesonga and Company Advocates, a respected Nairobi-based firm. His practice spans commercial litigation, environmental law, alternative dispute resolution, legislative drafting, corporate governance, among others. In December 2025, Eric Theuri was formally conferred the distinguished rank of Senior Counsel, one of Kenya's highest professional legal honors, recognizing his outstanding contributions to the legal profession and his exemplary record of service. He is the youngest Senior Counsel to be so honored, a milestone that underscores his professional achievements and leadership legacy. His tenure as LSK president was marked by advocacy for judicial independence, engagement on legal reform, and support for networks and mentorship for young lawyers. Beyond his presidency, he remains active in legal discourse and professional development, previously serving as on the LSK Council and leadership committees for many years. Our fourth judge is Honorable Antoinette Ogange. Honorable Antoinette Ogange is a distinguished magistrate of the judiciary of Kenya, admitted to the bar in 2017. She brings to the bench a wealth of experience in the adjudication of complex criminal, civil, and small claims matters, guided by a judicial philosophy anchored in rigorous evidentiary analysis, procedural integrity, and principled application of the law. Prior to her judicial appointment, she founded and managed a dynamic private legal practice where she litigated across diverse and technically demanding jurisdictions, including the Environment and Land Court. She subsequently served in the Office of the Attorney General, representing the state before the High Court. In that capacity, she handled complex public law litigation, advancing constitutional interpretation, administrative law principles, and matters of significant public interest. Honorable Ogange holds a Bachelor of Laws from the Catholic University of Eastern Africa, who are also participating, and is currently pursuing a master's in media and communication law at Daystar University, reflecting her keen interest in emerging legal frontiers, including digital governance, information rights, and media regulation. As a GLGI judge under the Green Law Global Initiative, Honorable Ogange contributes to advancing environmental jurisprudence, sustainability governance, and climate justice discourse. Her career reflects a sustained commitment to judicial excellence, integrity in public service, and and the progressive development of Kenyan jurisprudence. And then we have our fifth judge, who is the first person I ever heard the word environmental law from, because he was my lecturer in campus at Kabarak University. Our next judge is B.O. Akango, who is an advocate of the High Court of Kenya with over 20 years of distinguished practice, combining courtroom experience, academic scholarship, and international human rights engagement. He's the managing partner of B.O. Akango Advocates, where he has led complex litigation and advisory work spanning public law and international legal dimensions. He holds a Bachelor of Laws from Moot University and a Master of Laws, where he scored magna cum laude in international human rights law from the University of Notre Dame in the United States of America, a distinction that reflects both academic excellence and rigor. His postgraduate work deepened his engagement with global human rights systems and comparative constitutional frameworks. He is currently developing his PhD proposal under the theme, The Role of Non-Binding Norms in Promoting Respect for Human Rights, the case for RUGI guidelines. The role of non-binding norms will be very key in the non-binding nature of the ICJ advisory opinion, which is being interrogated. This work interrogates the legal and practical influence of soft law instruments, particularly the UN guiding principles on business and human rights. Mr. Akango combines experience as a practitioner, scholar, and mentor, and is also a senior lecturer at the Moot University, where he's taking his time to nurture the next generation of lawyers. Our sixth judge is Cynthia Rose Odongo, who is an advocate of the High Court of Kenya and a distinguished legal practitioner with extensive experience in specialized litigation, alternative dispute resolution, and environmental law. She currently serves as a legal consultant at Odongo and Associates Advocates, where she combines strategic legal acumen with practical guidance for clients navigating complex legal landscapes. She's a certified professional mediator, bringing a sophisticated and balanced approach to dispute resolution, ensuring that legal solutions are both just and sustainable. Holding a Master's of Law from the University of Nairobi, in environmental law from the University of Nairobi, and a postgraduate diploma from the Kenya School of Law, and a Bachelor of Laws from the Catholic University of Eastern Africa. Her deep expertise in environmental jurisprudence and climate governance has positioned her as a leading voice in advancing legal frameworks that protect communities and ecosystems alike. As a GLGI judge, she brings her profound judicial insight, mentorship, and commitment to legal excellence and to guide the legal minds. Our last judge, Njoki Kamau, who is a lead environment, social and governance advisor and the founder of Adena Consultancy, and also an advocate of the High Court of Kenya, whose work sits at the intersection of environmental law, sustainable finance, and responsible business governance. She is the co-founder and CEO of Adena Consultancy, an ESG advisory firm dedicated to helping organizations navigate the rapidly evolving landscape of sustainability regulation. A master's in environmental policy holder from the University of Nairobi, Njoki continues to contribute to high-level ESG advisory, sustainability governance, and capacity building initiatives across networks. She serves as a GLGI judge, where she brings her expertise in environmental law and ESG governance to evaluate emerging legal arguments on climate justice. Respected for her clarity of thought, policy foresight, and principled leadership in sustainability, Njoki continues to shape the evolving dialogue on ESG governance. Now, I just feel it wise that I've talked about them. I just want to call the judges who have not been seen. Just switch on your camera, say hi, and switch it off. Senior Counsel Eric Theory, just say your name and greet us, and then just switch off your camera. Senior Counsel? Yep.
Thank you, Brian. Can you hear me?
Yes. Perfect.
Good. Is it afternoon and good morning to all our participants? My name is Eric Theory, judge in this Moot Court, and I'm privileged and honored to be among all of you. Thank you.
Thank you so much, Senior Counsel. B.O. Akango.
Hello, everyone.
Hi.
I think my camera is still acting up a little bit, but you can hear me. Maybe in the
Yes.
course of time, I will resolve it.
Okay, no problem.
As you've heard, my name is Bernard Akango. I'm one of the judges participating in this moot court. It's my pleasure to join all of you, and I look forward to a very, very fruitful engagement. Thank you very much.
Thank you. Honorable Antoinette Ogange.
Good evening, good morning, everyone. My name is Ogange Antoinette. I'm glad to be part of the bench serving in this moot court, and I look forward to fruitful deliberations. Thank you.
Thank you, Honorable Cynthia Odongo. Judge Cynthia, are you with us? All right. She might not be there. Justice Njoki is also not there, so we'll just give it back to Wanjira to run the program. Thank you.
Thank you so much, Brian. We appreciate it. Let's give a round of applause to Brian with a show of emojis so that we also know that we're not alone on our side. So thank you so much, Brian, for this, for introducing the judges bench, who will be taking us through and listening to the competition, to the competitors as they argue. Right about now, I'm just gonna thank every one of you for being part of this conversation today. And there are so many of us who've joined us in between the session. We have not seen you, so I will kindly request that we take a virtual group photo. So I will request all our judges, all our distinguished speakers, team reps, and the general audience to just switch on your cameras for like a brief minute. We take another group photo in courtesy of everyone who's just joined us. We appreciate them. Thank you so much for everyone. So right about now, I'm gonna take it to Simon. Simon is our he's our team IT guru guy. He's going to talk to us and tell us what he needs from us. So Simon, over to you.
Thanks a lot to Wanjira for the opportunity. I think all of us can open the camera so that we take a virtual group photo, kindly. Kindly, all of us, let us open the cameras. Thank you. Thank you for all of you are opening, kindly. Kindly, let us open the cameras. All right, thank you. Okay, I'll take the photo in 3 steps. We have the first page. Just hold on. I'll count to 1, 2, 3. Thank you. Let me move to the second page. All right. I'll count again to 1, 2, 3. I'll move to the last page. All right, thank you. Hold on. I'll count to 1, 2, 3. Thanks a lot for your cooperation. That's all.
Thank you so much, Simon. We appreciate that. Thank you for all your efforts. Right about now, we're about to conclude this opening ceremony, and we're about to transition from dialogue to practice and from principle to advocacy. And this competition will officially commence shortly with the first oral hearing, where participants will begin presenting their arguments before the bench. But before we do that, I'm going to invite Brian, who is going to give us a problem overview, the moot problem overview, and the competition format. So I will welcome Brian again for this overview. Brian, over to you.
Thank you so much. Very briefly about the moot problem overview, which has been spoken about much. It's as Professor Patricia Mbote indicated, though fictional, it touches on real world issues. So the problem arises from a country known as Tanzania. Tanzania is a country which has a population that 70% of that population depends on second-hand apparel. for sale and for all that. The country Tanzania is also the largest importer of second-hand apparel, and most of this, according to scientific reports, was found that most of this second-hand apparel imported are unsellable. 35% is unsellable, which finds itself in landfills, in our drainage systems, as well as the same is burnt, emitting noxious greenhouse gases. So in line with the ICJ advisory opinion, the Parliament and the State of Tanzania enacted the TWISIA, the Textile Waste Act, which included, among others, regulatory issues that the second-hand apparel traders must undertake. For instance, digital traceability, extended producer responsibilities, and circular economy systems. So this law banned and regulated import and use and sale of second-hand apparel. So there's a group called SECA, which is the Coalition for Ethical Circular Apparel in that country, which indicates that they do their circular economy in their own way, and therefore the law is discriminative, and the ICJ advisory opinion is non-binding. And why should that government use a non-binding advisory opinion to create such a harsh law? The argument is the government should balance between economic rights and environmental rights. And throughout this discussion, that one will come out very heavily in that which right supersedes the other, how are they balanced, how will these governments operate in this balance. So this issue, the SECA indicated that the law is discriminatory and consequently petitioned the Supreme Court of their country in order to get an opinion. The Supreme Court upheld the decision by Parliament to enact the law, indicating state sovereignty in its legislative processes. This coalition again approached the African Court on Human and People's Rights, seeking their advisory opinion, and the African Court on Human and People's Rights indeed held as per the Supreme Court of Tanzania and found that the TWISIA law was lawful. Consequently, this managed to bring a lot of public uproar, and the United Nations General Assembly caught wind of that judgment and ruling, and what it did is it sought an advisory opinion from the ICJ, which culminated into the Moot problem. So the Moot problem is an advisory opinion from the ICJ, and since SECA, the Coalition for Ethical Circular Apparel, does not have locus standing to petition the ICJ. So what happens in this Moot problem is that the pleadings that were in the Supreme Court and the African Court of Human and People's Rights were submitted to the ICJ. So councils will argue, primarily putting forth the interests of the state primarily concerned, which is Tanzania. Tanzania is claiming state responsibility, state sovereignty in legislative process. And SECA is now an interested party in this Moot question, and they will also now be advancing their argument in that economic rights are also key to environmental rights. So that is briefly the Moot question. The competition format, as we indicated in our website in the rules, the preliminaries, which begin shortly, together with the quarterfinals and the semifinals, are fully virtual. And the finals will take place in Addis Ababa, Ethiopia, on the 18th, 19th, and 20th of June, which will be a physical finals. And in partnership with our partners here, we shall ensure that we make a proper finals for the flagship Green Law Global Initiative Moot Court competition. And that being said, that is the competition format, and that is the overview of the Moot problem. Thank you very much. Back to you, Angela.
Thank you so much, Brian, for those remarks, and we look forward to hearing what the teams are on board. To all participating teams, we wish you the very, very best as you embark on this journey of legal reasoning, advocacy, and discovery. To all our judges and partners, we remain deeply, deeply grateful for your time, for your expertise, and for your commitment to advancing environmental justice. And on behalf of the Green Law Global Initiative, I really want to say thank you for joining us today. This marks the official opening of the Green Law Global Initiative 2026 International Moot Court Competition. Thank you. Please stay on call as we proceed into the first competition, as we transition into the first moot session. So please remain on call. Do not leave. We hope to see you shortly. So thank you so much for joining us. We wish you all the very best to everyone and all the best. See you shortly.
Right. Thank you so much, Wanjira, for the very competent moderation. Now, as we transition into the virtual courtroom, I'll just request our honorable judges, Presiding Justice Helen Omondi, alongside Justice Matthew Emukule, alongside Justice Eric Theuri, to switch on your cameras, and also Lincoln Alexander School of Law from Canada will be taking on Africa Nazarene University. Lincoln Alexander School of Law is represented by two counsels, as well as Lincoln Alexander School of Law will be arguing for Azania, and Africa Nazarene University will be arguing for SECA. With that being said, we are now in a formal courtroom. This is not you should mute. Your videos should be off. Just ensure everybody is muted. Let us give the court the decorum it deserves. And now, participants also from Lincoln Alexander as well as Africa Nazarene, your videos should be on throughout, together with the judges' video. Justice Matthew Emukule, we still cannot see you, but we can see your roof. Yeah. Anyway, I give it now back to Presiding Justice Helen Omondi. The session is yours. Take over. Thank you.
Thank you very much, and welcome to this court session. The bench has already been introduced. I am not certain whether, Dr. Brian, you are the court assistant or the court clerk, or who will be serving as the court clerk. Perhaps you could clarify that first.
Yes, Wanjira, the moderator, is the court clerk.
You could call out the matter and the parties. Wanjira, can you hear me?
Yes. This is the Honorable Court is now in session. The Green Law Global Initiative Moot Court is convened for the hearing of the case of just 1 minute. Just give me 1 minute. I get this in order as I transition into this. All right. Yes. So just 1 minute. The Green Law Global Initiative Moot Court is convened for the hearing of the case and by the Lincoln Alexander School of Law representing the Judicial. Sorry, there's something that is happening on my background.
Let me just help you. You can mute, I help you. I can just help you in that. Yeah. Honorable members of the bench, as well as the general audience, this court is now in session. The court is ready to hear. This court is in session to issue an advisory opinion from the United Nations General Assembly, and fronting the position of Azania, the state primarily concerned will be Lincoln Alexander University, led by Jennifer Taliok, and those who will be the councils fronting the position of SECA will be Africa Nazarene University, led by Felicity Oware. The court is now in session. We are ready to hear the counsels for the applicants.
Thank you. Thank you. And for counsel for the applicants, you have 30 minutes within which to make your submissions. You may also indicate to the court how you wish to address, whether one will be a lead counsel and the other one assisting, or there'll just be one counsel making the presentation.
May it please the court. Honorable members of the court, my name is Jennifer Turlock, appearing as agent for the Republic of Azania, alongside my colleague Shefali Gupta. This case is about the rule of law in the age of climate change. Azania submits that it enacted legislation in accordance with international law. Ruling otherwise would not protect the rule of law. It would undermine it by refusing to recognize developments in climate change and international law. The TWCCEA legislation is necessary and proportionate and consistent with evolving international climate obligations, as well as properly designed to mitigate transboundary apparel waste. I will cover issues 1, 2, and 5. First, that the ICJ advisory opinion affirms a positive obligation of states to regulate transboundary value chains. Second, that there has been no breach of the due diligence obligation. For issue 5, I'll cover how the exposure of children and coastal communities to apparel-related pollution does not violate human rights obligations, but despite these 3 positions, we still need to enact the legislation. My colleague Shefali will cover issues 3, 4, and 6. For issue 3, that the TWCCEA's trade measures are lawful. For issue 4, that the EPR and digital traceability are proportionate regulatory measures. And for that Azania has already done what national law requires in including circular economy actors. Starting with issue 1, the ICJ advisory opinion affirms a positive obligation of states to regulate transboundary value chains, which Azania has done with the TWCCEA. Azania will be proceeding in the hierarchy of norms arising from Article 38 of the ICJ statute, first looking at applicable treaty rules, then customs, then general principles, then judicial decisions. I will proceed in that order. Starting with treaty rules. As the ICJ affirms, there's 3 legally binding instruments that states look to address the problems of climate change, namely the UNFCCC, the Kyoto Protocol, and the Paris Agreement. And positive obligation to do something about climate change has been recognized in treaties such as UNCLOS, Article 192, which consists of a positive obligation to take measures to protect the environment. In terms of customary law arises from 2 elements. First, a general and widespread practice among states, and second, if it's accepted as a law or arises out of a legal obligation. And under customary law, Azania has obligations to reduce waste. The principle of prevention as a rule of customary environmental law asks all states to use all means at their disposal to avoid activities causing significant damage to the environment of another state, as affirmed in Pulp Mills and the ICJ advisory opinion. And the positive obligation for states to do something about climate change has also been affirmed in recent cases in international law, such as Bonaire versus the Netherlands, where the court held that states have a positive obligation to do something about climate change, as well as in Veren Klima Senioren, where the court found that Switzerland failed to comply with its positive obligation by not implementing a sufficient regulatory framework. These cases support the advancements in the environmental rule of law arising from UNEP, as does Azania's legislation. In terms of judicial decisions, the ICJ clarified that states have a positive obligation, and in the advisory opinion, it says that waste is a challenge for the commons. If Azania doesn't implement this legislation, it will violate the ICJ opinion. And although there's arguments that the ICJ opinion is not binding, treaty and customs are binding, and the enshrinement of the ICJ opinion into local legislation is also binding. There's a major movement that has bypassed local law. Climate is a global issue. And an example of a court finding a positive obligation in Africa is in Wawuru versus Republic, where the High Court at Nairobi and the Ministry of Water asked the Ministry of Water and the County Council to construct sewage treatment works. As well as under the African Charter, Article 24, it references that all people shall have the right to a general satisfactory environment favorable to their development. So this is related to human rights, and we cannot allow Africa to be the planet's dump of this apparel. So the TWCCEA is lawful, necessary, and consistent with international obligations under climate change law, and it will reduce pollution, emissions, and flooding. There's also many African nations whose constitutions recognize the right to live in a healthy environment and have enacted environmental laws. For example, the right to a healthy environment in the African Charter led Kenyan and Nigerian courts to make important rulings on this right, finding it to be an essential part of the constitutional right to life. So in conclusion on issue 1, the ICJ advisory opinion affirms a positive obligation of states to regulate transboundary value chains, which Azania has done with the TWCCEA legislation. Azania now turns to the second issue and submits that Azania's failure prior to the TWCCEA to regulate secondhand apparel imports did not constitute a breach of the due diligence obligations under international law. However, Azania still needs to implement this legislation for going forward. In terms of treaty rules, Charter rights obligate states to reduce emissions with stringent or enhanced due diligence under Section 1. And as the ICJ opinion affirms, the Paris Agreement, which is binding, each party has a due diligence obligation to do its utmost to ensure that the NDCs it puts forward represent the highest possible ambition. And the ICJ, the IACTHR, and ITLOS have recently agreed that the standard with which states must mitigate is enhanced or stringent due diligence. Also, the ECTHR's Grand Chamber ruled that the standard is due diligence, and the ICJ advisory opinion echoed these findings. According to the Basel Convention, states must take all practical steps to ensure that wastes are managed to protect the environment. And that is what Azania is doing with this law. Under customary law, under the UN Charter Section 136, conduct required by due diligence has several elements such as taking precautionary measures. Azania followed customary laws, which state that parties are required to use all means at their disposal according to pulp mills, which is what Azania is doing with this legislation. In terms of whether the failure to enact this legislation previously was an internationally wrongful act, we can look to the two-part test for an internationally wrongful act, which is whether the conduct, the act or omission is attributable to the state under international law, and whether it constitutes a breach of the international obligation owed by that state to the injured state or international community. It wasn't an international obligation owed to the state or international community under a treaty or customary law. This is about pollution, emissions, and flooding in Africa, but it could affect countries in the future. In the alternative, there are defenses available to the responsible state which can preclude the wrongfulness, such as distress and necessity. And then in terms of judicial decisions, the ICJ affirmed that obligations for states include the duty to prevent significant harm to the environment by acting with due diligence. And under stringent due diligence from the ICJ advisory opinion, if there's no legislation of this nature, Africa could continue to have all this waste being received, and that could affect the global commons. The ICJ also affirmed in this advisory opinion that the positive obligations of due diligence extend to transboundary waste. So in conclusion of issue 2, Azania's failure prior to the TWCCEA to regulate secondhand apparel imports did not constitute a breach of the due diligence obligation under international law. However, Azania still needs to implement the TWCCEA legislation. Now moving to the last issue that I will cover before handing it over to my co-counsel. The continued exposure of children and coastal communities to apparel-related pollution does not violate international human rights obligations, including intergenerational equity, as articulated by the ICJ. However, Azania needs to enact legislation as waste impacts disproportionately affect children, coastal communities, and future generations. The relevant treaty here is the Convention on the Rights of the Child, a legally binding treaty. And as the ICJ advisory opinion affirms, in Article 24 of the Convention on the Rights of the Child, it affirms the rights of the child to the highest attainable standard of health. The Paris Agreement also states that parties should, when taking action to address climate change, consider the rights of children. In terms of judicial decisions, the Office of the UN High Commissioner for Human Rights has observed that extreme weather events and heightened water scarcity, which can be led to from things like extreme waste, are already major contributors to infant and child mortality and morbidity. And Article 14 of the African Charter on the Rights and Welfare of the Child on Health has relevance here as it ties into children's health. And children and some of the impacts that are occurring as a result of this transboundary waste, including children being exposed to toxic fumes, microplastics, and floods. This is why Azania implemented the TWCCEA legislation to prevent these types of harms from and to act in accordance with international law. So in conclusion on this issue, the continued exposure of children and coastal communities to apparel-related pollution does not violate international human rights obligations, including intergenerational equity, at least thus far. However, we need to enact legislation in light of the ICJ advisory opinion and other recent international cases that support it. Waste impacts disproportionately affect children, coastal communities, and future generations. Now I'll hand it over to my co-agent, Ms. Shefali Gupta, to cover the subsequent issues.
Thank you, Council. Maybe before Ms. Gupta addresses the court, my brother, Judge Theory, anything you'd wish Council to clarify from her submissions?
Presiding Judge, nothing on my end.
About my brother, Judge Mukule? Judge Mukule, you are muted. Do you have anything for Council to address, to respond to?
No, none from my end. Can you hear me?
Yes, we can hear you. Thank you very much. And now we'll allow Ms. Gupta to address us.
Thank you. Honorable members of the bench, my name is Shefali Gupta, agent appearing on behalf of the Republic of Azania. Azania enacted the TWCCEA in good faith in direct response to the ICJ Climate Advisory Opinion to address a documented and severe environmental crisis. My submission addresses 3 issues. Issue 3, that the TWCCEA's trade measures are lawful. Issue 4, that EPR and digital traceability are proportionate regulatory measures. And issue 6, that Azania has already done what international law requires in engaging circular economy actors. I will address each in turn. Turning on issue 3, GATT, or the General Agreement on Tariffs and Trade, is a multilateral treaty to reduce trade barriers such as tariffs and quotas. It is binding. Article 20 expressly permits measures necessary to protect human, animal, or plant life or health under Article 20b. Azania is not required to find a perfect measure, only a reasonable one that is not arbitrary. The TWCCEA directly addresses documented public health harms, such as toxic burning, emissions, and flooding. That is precisely what Article 20B was designed to permit. On Article 20B, yeah. Article 20G, also binding, it recognizes marine ecosystems and coastal environments as exhaustible natural resources within the meaning of that provision. The TWCCEA's import restrictions are directly aimed at conserving those resources. The domestic dimension of waste management is being addressed progressively through the Act's EPR and reporting framework. International law does not require perfection on day one. It requires good faith movement in the right direction. Article 24 of the African Charter, also binding, imposes a positive obligation on Azania to ensure its people enjoy a satisfactory environment. Textile waste polluting coastal zones and informal settlements is a direct threat to that right. Azania is not restricting trade arbitrarily. It is fulfilling a binding human rights commitment to its most vulnerable communities, including children, as my co-agent mentioned. The Kenyan High Court in Waweru and Republic, which is a persuasive comparative jurisprudence, directly applied Article 24 in paragraph 22 and held that the right to a clean environment is inseparable from the right to life. Azania's obligation under Article 24 is therefore a commitment to life itself. Azania submits on Issue 3 that the TWCCEA's trade measures are lawful under GATT Article 20 and consistent with the African Charter. I will now be addressing Issue 4. The TBT, or the Technical Barriers to Trade Agreement, which is binding, recognizes WTO members' rights to implement measures to achieve legitimate policy objectives, including the protection of human health and the environment. Both EPR and digital traceability serve that purpose. Government-commissioned environmental audits revealed in the facts that 35 to 40% of imported garments arrive unsellable, and every importer contributes to that problem, which means that the EPR attaches responsibility to that activity. Again, the Kenyan High Court in Waweru and Republic in paragraph 27 applied the polluter pays principle and rejected the argument that compliance costs justify non-compliance, holding that there is no price for the lives of people endangered by pollution. EPR is not punitive. It is the polluter pays principle in action. The ICJ Climate Advisory Opinion, also persuasive, confirms that due diligence entails not only adoption of appropriate rules, but a certain level of vigilance in enforcement and administrative control. And this is from Pulp Mills, the same case my co-agent cited, which is binding ICJ jurisprudence. Digital traceability is precisely that enforcement mechanism. The UNEP Sustainability and Circularity in the Textile Value Chain Report, also persuasive, confirms that transparency and traceability are critical enabling factors in practically all initiatives to improve textile sustainability. In terms of EPR, the TWCCEA already recognizes certified circular enterprises as ecosystem partners. Azania built in a distinction, and CISA cannot further prove the EPR system is disproportionate, as the facts do not tell us how it operates in detail. And this is a point from assumption and not evidence. This is also new legislation adopted directly in response to an international advisory opinion. States must be given deference to develop their frameworks. As I mentioned before, international law requires good faith and not perfection. So on Issue 4, Azania submits EPR and digital traceability are lawful proportionate regulatory measures. I will now be addressing Issue 6. The Paris Agreement Preamble, which is persuasive, recognizes the importance of engaging various actors, but critically adds that engagement must be carried out in accordance with respective national legislations of parties. This means states retain sovereignty over how non-state actors engage domestically. The TWCCEA is Azania's national legislation on this point. Decision 1 CP 21 paragraph 118 of the same Paris Agreement is also persuasive and only encourages parties to work with non-party stakeholders. Paragraph 133 of the same place is also persuasive and only welcomes their efforts. So if you take a look at these words, welcome and encourages, these are invitations, not binding obligations. The 2030 Agenda for Sustainable Development, also persuasive and not a treaty, talks about financing in paragraph 41. And the private sector acknowledgement is one sentence at the end of a financing provision, meaning it cannot be used as a foundation for binding governance obligations. The ICJ Climate Opinion, paragraph 136, confirms due diligence varies depending on each state's capabilities. Azania is a lower middle income state and should be given deference, as I mentioned. They cannot afford the privileges of first world countries and are doing their best to develop a legislation. Formal recognition of circular enterprises as ecosystem partners represents Azania acting to the best of this ability. On issue 6,
Council note, you have 5 minutes.
Thank you. Azania submits on issue 6 that it has complied with what international law actually requires. Honorable members of the bench, Azania respectfully asks the court to find that the TWCCAA's trade measures satisfy GATT Article 20 and fulfill Azania's obligations under the African Charter. Second, that EPR and digital traceability are lawful proportionate measures justified under the TBT agreement and the ICJ climate opinion. And third, that Azania has engaged circular economy actors in good faith in accordance with its national legislation as international law requires. Unless the court has any questions, this concludes Azania's submission. Thank you.
Thank you, Council. Judge Theory, any issues for Council to address?
None from my end, presiding judge.
Judge Olukule?
None from my end, Judge.
Thank you. Ms. Gupta, just one issue for clarification on the engagement with circular economies. Do you want to expound a little on that when you say that Tanzania has engaged with the circular economies?
Yes. Would you want me to address issue 6? Sure. So as I mentioned in my submissions, there is no binding international law that requires Azania to allow circular economy actors to engage heavily with Azania. As I mentioned before, the Paris Agreement, although it is binding, the sections that I mentioned, the preamble and Decision 1 CP21, they are persuasive. And as I mentioned, it only encourages and welcomes their efforts. So Azania did recognize CISA as a circular economy actor, and that is all they are required to do. So they're not required to have them engage in a very heavy manner.
Thank you, Council. All right, we then now invite the response. And I think the respondents are represented by Africa Nazarene.
This honorable court is ready to hear the councils representing SECA. We now invite council representatives. Councils, you may proceed.
Presiding Judge, distinguished members of this honorable court, Your Excellencies, may it please this court. My name is Amani Andika, and I appear before you on behalf of the Coalition for Ethical Circular Apparel. Appearing alongside me is my co-agent, Ms. Feli Dare, and for the purpose of record, our team code is Team GLGI 7. Of the 30 minutes graciously allocated to us by this honorable court, I'll be using the first 16 minutes of our time to address the preliminary issues of jurisdiction and admissibility, as well as issues 2, 3, and 4 for determination, where I shall demonstrate that the Republic of Azania failed to exercise due diligence and that its regulatory measures are disproportionate, and finally, that its framework unlawfully burdens sustainable actors. My co-agent will use 14 minutes to address issues 1, 5, and 6, which concerns states' obligations, human rights implications, and the role of social enterprises, before finally concluding with our prayers. We would further like to reserve 2 minutes for SAR rebuttals. With the court's permission, I would now like to proceed to the preliminary issues on jurisdiction and admissibility before finally delving into the substantive issues. Turning to jurisdiction, Your Excellencies, the coalition would like to affirm this court's jurisdiction, that it is both fully competent and appropriately seized to render the requested advisory opinion. The court's jurisdiction is grounded in Article 65 of its statute, read together with Article 96 of the Charter of the United Nations, which empowers this honorable court to give an advisory opinion on any legal question at the request of a duly authorized organ of the United Nations. The questions presented before this honorable court concern the scope and content of obligations under international law relating to environmental protection and state responsibility. This honorable court affirmed in the case of legality of the threat or use of nuclear weapons in the year 1996, and further reaffirmed in the legal consequences of the construction of a wall in the occupied Palestinian territory in the year 2004, that a question does not lose its legal character merely because it arises in a politically sensitive context. Turning to admissibility, KECA submits that there are no compelling reason for this court to decline to exercise its jurisdiction. In the Western Sahara advisory opinion, the court made it clear that only compelling reasons can justify such a refusal, and those reasons are to be interpreted narrowly. No such reasons arise here. The fact that the issues may relate to the conduct of states or involve complex factual or policy considerations does not render the request inadmissible. This court further made it clear in the case of legal consequences of the construction of a wall in the occupied Palestinian territory in paragraph 47, that the lack of consent by a state does not deprive this honorable court of its advisory jurisdiction, precisely because advisory opinions are not binding and do not determine disputes between parties. Having concluded on the preliminary issues, allow me to turn your attention to the second issue for determination before this honorable court. Your Excellencies, turning to issue 2, this esteemed court is invited to determine whether Azania exercised due diligence in preventing environmental harm. Your Excellencies, environmental harm rarely occurs in a single moment. More often, it is a result of delay, hesitation, and regulatory silence in the face of unknown risks. International environmental law exists precisely to prevent such situations. It requires states not merely to react to environmental damage once it has occurred, but to act with foresight and diligence when the risk of harm becomes foreseeable. It is the position of the coalition that Azania failed to exercise the level of due diligence required under international law, because despite being aware of the environmental risks associated with the activity in question, Azania failed to exercise the level of due diligence required. Madam President, members of this honorable court, international environmental law imposes on states a well-established obligation not to allow activities within their jurisdiction to cause significant environmental harm. The International Court of Justice reaffirmed due diligence in the case of Argentina versus Uruguay in the year 2010 at paragraph 101 and 197, where it provided that a state must act where there is a risk of significant transboundary harm and must undertake environmental impact assessment where there is a risk of significant adverse impact. In the present case, the risk posed by the importation of unsellable garments was not speculative. Your Excellencies, kindly move with me to page 3 of the factual record. It indicates that a substantial proportion of imported textiles could not be reused, and instead it accumulated as waste, therefore creating pressure on landfills and coastal environments. Once such a risk became apparent, Azania was under a duty to assess the environmental impact of continued importation and to introduce reasonable regulatory measures to prevent further harm. In the Corfu Channel case of United Kingdom of Great Britain versus and Northern Ireland versus Albania in the year 1949, The court emphasized that knowledge of a risk engages responsibility where a state fails to take preventive action. The obligation arises at the point of knowledge or constructive knowledge. The advisory opinion of 2025 that was rendered by this Honorable Court in paragraph 213 further reiterates that a lack of fully scientific certainty does not excuse inaction where there is a risk of serious environmental harm. This further affirms that states must act even when science is not completely conclusive, provided there is a risk of serious environmental harm, which further aligns with the precautionary principle reflected in Principle 15 of the Rio Declaration, which was further relied in the case I had earlier cited of Argentina versus Uruguay. Once these consequences became apparent, Azania was under a duty to evaluate the risk and to introduce reasonable preventive regulations. Turning to our second limb of argument, distinguished members of the bench, we do take note of the fact that the Republic of Azania may invoke developmental status and capacity limitations. However, we submit that Article 3.1 of the United Nations Framework Convention on Climate Change, while recognizing common but differentiated responsibilities, does not absolve state of responsibility. Even accepting that the fact that Azania is indeed a developing state under paragraph 2 of the Statement of Fact, it remained a duty to adopt at least minimal regulatory measures once environmental risks became apparent. Your Excellencies, the coalition does not suggest that Azania was required to adopt complex regulatory systems. However, due diligence required at least minimal preventive steps. They could have included inspection thresholds for textile imports or even basic waste management requirements. Article 12 of the International Law Commission's Articles on State Responsibilities provide that there is a breach when an act is not in conformity with international obligation at the time it occurs. Moreover, Article 24 of the African Charter on Human and People's Rights recognizes the right of people to a generally satisfactory environment favorable to their development. Your Excellencies, I now turn to issue 3, which concerns whether measures adopted pursuant to the environmental obligations may justify limitations on international trade. The coalition submits that while such measures may be justified in principle, they must remain proportionate and must not unduly burden actors who contribute to environmental sustainability. The coalition submits that the Textile Waste Control and Circular Economic Act in its current form does not constitute a lawful exercise of regulatory authority. While states undoubtedly possess the right to regulate in public interest, that right is not without limits. International law requires the principle of sustainable development as articulated by this Honorable Court in the case of Gabrikovo-Nagrimaro's project, which requires a careful balancing between environmental protection and economic activity. The difficulty with the Textile Waste Control and Circular Economic Act is that it seeks to address environmental harm, but it does so in a manner that disproportionately burdens the transactional actors and disrupts the established circular economy without sufficient justifications. The Act imposes stringent requirements that effectively restrict the importation of second-hand textiles. Moreover, international law does not permit states to adopt measures that are necessarily trade restrictive where less restrictive alternatives are available. A more proportionate response would have focused on strengthening domestic waste management system and improving sorting and recycling capacity while further collaborating with exporting states rather than imposing sweeping regulatory barriers. Finally, on issue 4, this Honorable Court is asked to determine whether digital traceability and extended producer responsibility requirements on whether they constitute unlawful regulations or unlawful discrimination. The coalition submits that although these mechanisms are legitimate in principle, the implementation in the present case results in disproportionate burdens that effectively exclude informal economic actors. The coalition submits that Azania incurs international responsibility for the harm arising in its failure to regulate and from the consequences of its subsequent measures. In this case, both elements are satisfied. The failure to regulate is attributable to Azania as an omission within its jurisdiction and constitutes a breach of due diligence obligation to prevent environmental harm. The requirement of causation does not demand absolute certainty, particularly in cases such as this involving environmental harm. The court has recognized in cases such as certain activities carried out by Nicaragua in the border area that responsibility may arise where there is sufficiently direct and foreseeable connection between the conduct and the harm. That threshold is clearly met here. The influx of unsellable textile waste and its environmental consequences are a direct and a predictable outcome of the absence of regulation. It is no answer for Azania to invoke the complexity of global value chains. While climate change is indeed a collective problem, that does not absolve individual states of their obligation. Each state is responsible for ensuring that activities within its jurisdiction does not contribute to environmental harm. To accept Azania's positions in this case, Your Excellencies, will be to render due diligence obligation meaningless and it is in such a situation where the due diligence context is most needed. Accordingly, the coalition respectively submits that Azania's failure to regulate constituted a breach of international law and that the Act does not meet the requirements of a lawful and proportionate regulations. Having concluded on my submissions as lead agent, I would now like to pass the baton to my co-agent, Ms. Felidea, who shall be guiding the court on the remaining issues and further conclude by stating our prayers, unless the bench has any clarifications on our submissions.
Thank you, Council. Judge Theory, any issues you'd want Council to address?
Presiding Judge, I think I want to thank the Council for their beautiful submissions. I have nothing to ask.
Judge Mukule, anything that you'd want Council to?
None at this point, Presiding Judge.
Then have the rebuttals.
Your Excellency, Presiding Judge, we would like to make a preliminary question on the submissions of Second Counsel for KECA.
I'm so sorry. That is Ms. Felicity.
Yes, thank you very much.
Beg your pardon. Please go ahead.
Her Excellency, Presiding Judge, Your Excellencies, may it please the court, my name is Oware Felidea, as earlier introduced, taking up the baton from the First Counsel for KECA. I will be using 14 minutes of this honorable court's time to canvass our client's position on the merits of Issue 1, on the ICJ advisory opinion, Issue 5, on the exposure of children and coastal communities to pollution, as well as Issue 6, on the role of social enterprises. I will also conclude by stating our prayers. Unless directed otherwise, I would like to begin. Your Excellencies, the case before us stands upon a state which has without shame spat on the very rights of its citizens. The question before us is whether international law can come to the rescue of over 2.5 million youth and women whose livelihoods have been sacrificed on the altar of poor legislation. The first issue tabled before this court is whether the ICJ advisory opinion affirms a positive obligation upon states to regulate transboundary value chains. And for the purposes of structure, I will be canvassing this issue in one head of argument to demonstrate that it indeed affirms a positive obligation. The present dispute, Your Excellency, comes from Part 1 and 2 of the Statement of Facts. And when you move with me here, Your Excellencies, we can see that the state of Azania enacted the Textile Waste Control and Circular Economy Act, herein the TWCCE Act, in a bid to respond to environmental degradation happening within the country. And even in the face of the Act posing stringent measures upon the economic livelihoods of the citizens of Azania, the opposing councils of Azania have stated it as a legitimate response compliant with international law to the environmental harm at hand. It is our assertion that the principle of due diligence had not been satisfied, and therefore the Textile Waste Control and Circular Economy Act cannot be a lawful response to environmental degradation. The opposing council of Azania has put before this court the fact that the advisory opinion is merely suggestive before this court. However, we seek to assert that the position of this court on such matters, putting persuasive reliance on the case, of Legality or the Threat of Use of Nuclear Weapons Advisory Opinion of 1996 is that where the ICJ advisory opinion raises a question on customary international law, then its interpretation can be held to be binding upon the state. The question thus is whether in the context of the regulation of transboundary value chains, whether there is a question of customary international law, and the said can be demonstrated by invoking Article 38 B and C of the ICJ statutes when read in conjunction with this court's ruling in the case of Nicaragua versus the United States of America in 2015. The two requirements for customary international law to be established are that of state practice and opinio juris. In matters state practice, we can see that there is a consistent general practice by states owed from Article 2 of the United Nations Framework Convention on Climate Change, which provides that states have an obligation to ensure that activities within its territory do not cause harm to extending states. In matters opinio juris, we assert that there is indeed a belief in the state of Tanzania that the ICJ advisory opinion can be an authoritative status that guides on the state's legally binding international obligations. And this can be gotten from Part C of the Statement of Facts, which when you move with me, Your Excellencies, we can see that parliamentarians cited the ICJ advisory opinion as an authoritative source of the state's international legal obligations. Having demonstrated that both state practice and opinio juris have been established in the present matter, we seek to affirm that the ICJ advisory opinion can indeed be interpreted as authoritative and legally affirming a positive obligation for states to regulate transboundary value chains. At this juncture, Your Excellency, the question that you might have is if it indeed affirms a positive obligation to regulate transboundary value chains, does the enactment of the Textile Waste Control and Circular Economy Act not manifest a compliance with the said obligation? And this, Your Excellency, guides me to issue 5 brought before the court, where we will demonstrate that although the continued exposure of children and coastal communities to pollution that is gotten from circular-related apparel can indeed raise concerns in international human rights, it is still our assertion that any legislation that is adopted towards curbing the same extent must be proportional and in respect of existing rights. Your Excellencies, turn with me to Part B of the Statement of Facts. We can see that 35 to 40% of second-hand apparel arrives unsellable by default. And this is because of contamination, oversaturation, and even poor quality. The said garments, Your Excellencies, are then disposed openly in dump sites, in river systems, and even in coastlines, causing environmental degradation. And the opposing councils of Tanzania have made a futile attempt to invoke Article 24 of the African Charter, which states that people have a right to a sustainable environment that is conducive for their development. They have raised Article 24, trying to prove that the enactment of the TWCCE Act was simply in a bid to curb the environmental degradation that was happening. However, Your Excellency, it is our assertion from Part A of the dispute that the measures adopted by the Act were too stringent, Your Excellencies. We can see that they increased operational costs and they also had high eligibility requirements. This strategically disadvantages the smaller operators, Your Excellencies, and is a direct violation of their right to work. In matters proportionality in environmental matters, the guiding principle is the common but differentiated responsibility that is embedded under Principle 7 of the Rio Declaration on the Environment and Development when read in conjunction with Article 3 of the United Nations Framework Convention on Climate Change. The common but differentiated responsibility states that any state whose contribution to greenhouse gas emissions is significantly negligible ought not to share the same burden as those of countries who are major contributors of greenhouse gas emissions. This said flexibility for negligible contributors also has to be reflected in the flexibility of legislations that are enacted for the same result. Conversely, Your Excellency, when we turn to the present state, we can see that the measures adopted under the Act were too stringent, having high eligibility requirements and even pushing operational costs that are burdening the smaller operators. This cannot be held to be a proportional method of environmental conservation. Since it violates the very right to work, Your Excellency, it is our assertion that it is inconsistent with international law. In conclusion, Your Excellencies, I turn to issue 6, where we will demonstrate that social enterprises acting within the circular economy can act as legitimate government actors in enhancing climate action. The Council for KECA would like to bring to the attention of this court that international law has evolved in a manner that moves from a state-only focused regime in matters fighting against climate change to recognize the role of social enterprises. This can be seen, Your Excellencies, from readings of paragraph 6 of Article 6 of the Paris Agreement, which encourages cooperative approaches to enhance climate action. It is indeed interesting that the Council for Azania has stated that there is no legally binding authority which places an obligation upon the state to incorporate cooperation with social enterprises, especially those working within the circular economy. This is because the United Nations, apart from the Paris Agreement, which is binding upon these states, the United Nations Environmental Program report that was done in conjunction with the World Bank, termed the 2020 Sustainability and Circularity in the Textile Value Chain, stated that private actors, such as those in social enterprises, are essential in waste management and are the only way to give developing countries the capacity to be able to fight against climate change. On a practical note, Your Excellencies, we would like to put a case in point of Egypt, Cairo. In the city of Cairo, Your Excellency, we find a network of social enterprises, that is non-state actors, called the Zabelin, who actively participate in door-to-door waste collection, reuse, and even sorting, Your Excellencies. And they have been able to reach higher recycling rates than even formal sectors that have been set up by the government. This clearly demonstrates an intersection between non-state actors and government actors in the fight against climate change. It is therefore apparent, Your Excellencies, that social enterprises operating within the circular economy can also contribute significantly towards the fight against climate change. This position has also been reiterated in jurisprudence, as this very court, in the case of pulse mills on the river Uruguay, Argentina versus Uruguay, when discussing matters of environmental conservation, stated that all affected parties, be it those who are contributing resources or those affected by legislations that are made in matters environment, ought to be involved in matters consultation, prior notification, and even cooperation when we are enacting legislation towards environmental conservation. When applied in the present instance, Your Excellency, this would mean that social enterprises also need to be involved, given prior notice, and even incorporated when we are enacting legislations towards environmental conservation. Since the same was not adopted by the state of Azania, the social enterprises were not involved in making of the Textile Waste Control and Circular Economy Act, and neither was a prior notification given even to the 2.5 million youth and women who are involved in this sector, Your Excellency. It is our assertion that the state of Azania is in violation of international obligations. With this, Your Excellencies, I have reached the end of my submissions, and I seek to make 4 key prayers on behalf of the client, the Coalition for Ethical and Circular Apparel. First, a declaration that the state of Azania's Textile Waste Control and Circular Economy Act is inconsistent with international obligations because it fails to meet the standards of proportionality and even intergenerational equity. Second, we seek that this court recommends that Azania revise its legislation to meet the proportionality thresholds that are given by international law. Third, to affirm the importance of a common but differentiated responsibility when enacting legislation towards environmental conservation. And lastly, to declare that the circular economy actors are indeed vital players when it comes to the fight against climate change. With that, Your Excellencies, we have reached the end of our submissions and we would like to cede the floor back to the bench. Thank you very much.
Thank you very much, Council. I'll find out from my fellow judges, Judge Theory, any issue you'd want Council to respond to?
Presiding Judge, there's just something that I may want the Council to explain when they indicated to us that the enactment of the Act was not as a result of it's not a legitimate response to the question of due diligence. In light of the ICJ advisory opinion and balancing the human rights element vis-a-vis the need to have a clean, the state obligation to have a clean environment. What exactly are your issues with regards to the state of Azania in failing to undertake a due diligence on that aspect?
Much obliged, Your Excellency, and thank you very much for that question. We do take note of your concern on the elements of lack of proportionality when we say that the Textile Waste Control and Circular Economy Act was not a legitimate response. And we will answer this question in twofold. First, to demonstrate how it is not a lawful limitation of rights, even when we consider the right to a clean and healthy environment. And second, to show that there existed lesser restrictive means within which the state of Azania could have achieved the promotion of the right to a clean and healthy environment without violating the right to work for the citizens. Due diligence, Your Excellencies, as was defined under paragraph 108 of Costa Rica versus Nicaragua, this court's judgment in 2015 states that a state has a duty to use all appropriate and proportionate, Your Excellency, measures to enhance environmental conservation. It is our assertion that the Textile Waste Control and Circular Economy Act was not a proportional measure because it sacrificed the right to work upon the altar of the right to a clean and healthy environment. In matters proportionality, Your Excellency, we do take note of the fact that the right to work is not absolute and it can be limited as is under the International Convention on Economic and Social and Cultural Rights. However, General Comment number 14 of the United Nations Committee on the Economic, Social and Cultural Rights states that any such limitation should be in a manner that does not destroy the essence of another right. In this case, Your Excellency, the essence of the right to work has been destroyed because the livelihoods of smaller operators, 2.5 million youth and women, Your Excellencies, have been sacrificed in the name of upholding the right to a clean and healthy environment. Closer home, even in the state of Kenya, proportionality, as was interpreted in the case of Okiya Mtata versus Communication Authority of Kenya, a case which we rely on persuasively, stated that for proportionality to be met, the least restrictive means have to be used. And it is incumbent upon the alleger to prove that lesser restrictive means existed. It is our assertion that the alternative means by which they could have achieved the right to a clean and healthy environment and the fight against climate change would look like a gradual phasing out of the circular economy in quarters so as to allow the citizens who are involved, which is the 2.5 million youth and children, to have time to pivot into other industries that are environmentally sound, Your Excellency. I would like to strongly bring to the attention of the court that this circular apparel sector has existed in the manner that it did for 3 decades, Your Excellency, pass on to the fact pattern. For 30 years, people have depended on the circular economy for their economic livelihoods. And a disproportionate measure, applying stringent measures all of a sudden, Your Excellency, does not give them any time to adapt, and this is a direct violation of their rights, Your Excellency.
Council, 30 seconds, please.
Thank you very much for that question, and I see the floor back to the bench again.
Thank you, Council. My brother, Judge Mukule, anything you'd wish Council to respond to?
Presiding Judge, I've heard the Council very, very clearly. My little beef is in protecting the rights of persons engaged in the circular economy. Should they be expressly provided for in legislation, or merely satisfied by virtue of participation in discussions on enactment of that law as is the practice in Kenya? Council.
Much obliged. In the involvement of persons within the circular economy, it is our submission that they should not only be involved in matters of public participation as is in the state of Kenya, but that legislations should also be reflecting the fact that there are leaders towards circular economies. When they are in coalitions, Your Excellency, for example, that of our client, these circular economies coalitions ought to be recognized in legislation and involved even in decision-making processes. Thank you.
Thank you. That's all from my end.
So we have the rebuttals.
Council's note on your rebuttals, you have 10 minutes each. Thank you, councils. We may proceed with the councils representing the state of Azania.
Thank you, honorable members of the bench, and to our friends. We will address issues of first the jurisdiction, then issue 1 on the ICJ opinion, issue 2 on due diligence, and issue 5 on children. Then my co-agent will address issues 3 on lawfulness, issues 4 on EPR and digital traceability, and issue 6 regarding engaging the circular economy. Starting with jurisdiction, we do not refute our friend's assertion about the court's jurisdiction of the ability to provide an advisory opinion here. Azania would like to make a general note that our friends have used case law from years including 1996 to 2015 to define certain terms. But Azania contends that these terms need to be read in the context of climate change, which was not as present at that time, as well as more recent international climate law decisions, such as the ICJ 2025 advisory opinion, as well as international judicial decisions such as Bonaire versus the Netherlands and Klima versus Signoren. There's simply more climate science available and more climate effects being held, so that needs to be taken into consideration. Azania would also like to clarify that Azania is not trying to eradicate the circular economy industry with this legislation. Now moving to issue 1 on the ICJ opinion and its level of bindingness. Our friend submitted that due diligence was not satisfied, so TWCCEA cannot be a lawful response. It's Azania's submission that due diligence is not a prerequisite to enacting a law. it seems that both parties agree that there are positive obligations on states to take actions regarding climate change. And that's what Azania was doing through enacting the TWCCEA. Now moving to the issue of due diligence. There's a bit of a conflict because Azania understands that our friends mentioned on issue 1 that Azania was not stringent enough, and that on issue 2, Azania was too stringent. So Azania believes that Azania was following its due diligence obligations in all cases, and would like to draw the attention to the hazmat argument about how low economy countries need to allow for some environmental harm for industrialization and then be able to address it through sustainability measures and legislation when they have enough resources. Azania allows secondhand imports, particularly so that those who cannot afford clothing can have access to them. And now that Azania is in a better place to be able to enact legislation to combat the waste issues associated, Azania has done so. It's also important to note that if Azania were to only enact minimal requirements as part of a legislation, it would not solve the issue, which is why Azania needed to implement the TWCCA. It's the main way to address this problem, and it's action, not merely a checklist that shows Azania is doing something. It does sound on this issue number 2 that our friends were and are interested in us implementing legislation. So that's what we've attempted to do here, and we believe it's unsatisfactory of both our international and local environmental law requirements. And then on issue number 5 regarding children, this was an argument of measures being too stringent. However, our argument is that we were following stringent due diligence. And then finally, on the argument that countries in the global south should not have to share the same burden as countries in the global north, we concede to that, but also wanted to mention that Azania is trying to be a leader in Africa and a leader that can influence not just countries in Africa, but also in the global north through this legislation, and minimize waste to open up opportunities for revenue generation associated with sustainability, such as green industrial parks, a concept from Ricardo Hausman involving using the natural resources to implement things like solar to generate more revenue for the country. And now I'll pass it to my co-agent Shafali to cover the balance of the rebuttal.
Honorable members of the, oh, sorry.
Go ahead.
Can I begin, or would you like to ask my co-counsel questions?
No. Please go ahead. Thank you.
Thank you. Honorable members of the bench, I will be addressing issue 3, issue 4, and issue 6. Beginning with issue 3, whether the TWCCEA was lawful. My friends on the other side mentioned that the measures were too stringent, including increased operational costs and it disadvantages smaller operations through a violation of the right to work. They also mentioned that there was no domestic implementation of mitigating the impacts of the secondhand apparel, and that Azania was burning the clothes instead of implementing other measures. In response to those arguments, we hold that we need to hold all importers responsible and cannot give them a free pass for any harm that they do to the environment. And in terms of burning the clothes, I ask another question in response. What other measures did Azania have to get rid of the pollution that the clothes were causing? The only way to do this was through the TWCCEA. And in terms of the existing clothes that were already polluting Azania, they had to be eradicated through burning. There was no other measure that we could implement. And the facts of the Moot also mentioned that 35 to 40% of secondhand garments are unsellable upon arrival. This means that we needed to enact a blanket legislation in order to combat this problem, because if the garments are unsellable upon arrival, we cannot implement the other measures that my friends mentioned, such as improving the sorting and recycling capacity. We need to attack the source itself. And like my co-counsel mentioned also, the TWCCAA is the main way to address this problem, and the less stringent measures would just seem like a label we are slapping on or a checklist that we are trying to fulfill. I will now be moving on to issue 4, the EPR and digital traceability. So my friends on the other side mentioned that this is this could cause a lot of operational costs for CISA down the road, as they are not large corporations. However, upon the facts that we received, there's no evidence of any statistical evidence that it will impose such a serious burden. So this is an argument based on assumption and not evidence. Also, my friends on the other side mentioned that it violates the right to work. However, a right to work violation requires proof that the regulatory measure actually prevents people from working, not that it just makes working more difficult or costly. And again, this is an evidence issue. The Waweru court also at finding 4 rejected the argument that compliance costs justify non-compliance. And it stated that sustainable development. Yes?
Councillor, you have 1 minute.
Okay. And so compliance costs cannot justify non-compliance. Moving on to issue 6, my friends on the other side mentioned that international law has evolved from state-only focus to recognizing the role of social enterprises. And they mentioned that there is a higher recycling rate when land state actors and government actors work together. I would like to conclude that this is irrelevant, as a higher recycling rate will not solve the problem here. And this is a very severe situation where we need to eliminate the source of the imports in the first place, further justifying the TWCCEA. Thank you. Those are my submissions.
Thank you, Council. From the rebuttals, Judge Theory, anything you'd wish addressed?
Presiding Judge, I have nothing.
Judge Mukule, are you there?
I'm there. And no, nothing.
Thank you, Judge. Then we can get the rebuttals from Africa Nazarene.
The court will hear the rebuttal representing SECA. Please note you have 10 minutes. You can now start.
Thank you very much once again, Your Excellency. Having listened carefully to the submissions of councils for Azania, the councils for KECA would like to make the following rebuttals. Second council for the state of Azania has stated that the only way to get rid of the clothing that has been disposed of was by informal banning, Your Excellency. Put into consideration that the state of Azania is claiming that they are in a bid to curb environmental degradation. From the fact pattern, part B, it is evident that scientific studies have shown that what contributes to the environmental degradation is in fact the informal burning of apparel, which reduces black carbon and toxic emissions, Your Excellency. It is our submission thus that this would be a regress in terms of environmental conservation, and informal burning is not a way to push forward climate change action, but it is in fact one that takes us back into the problem. They have also stated that the cases cited, the first council for the state of Azania stated that the cases which have been cited by councils for KECA have not reflected the evolving nature of climate change in international law, but have utterly failed, Your Excellency, to show what point of evolution is lacking. They have stated that the councils have not relied upon the 2025 ICJ advisory opinion on climate change, which is in fact inaccurate to the present instance. They have also stated that the first council stated that the measures by Azania were not stringent enough, and I have stated that they were extremely stringent. We would like to make a clarification that First Council posited that the actions by the state of Azania were not timely enough. They came in after 30 years, Your Excellency, which is not a progressive realization of that right, but it is a delay which is in contravention of their obligation to due diligence. I, on the other hand, stated that the measures under the Act were too stringent, Your Excellency, and too soonly adapted without any form of nuance to allow the citizens who are involved in this sector to pivot into other sectors that are environmentally sound. Lastly, they have claimed that the measures which have been recommended by the councils for PECA, that is by the gradual phasing out of the circular second-hand apparel in quarters, is not effective enough, Your Excellencies. But this court, in the case of whaling in the Antarctic, Japan versus Australia, was clear to hold that any claim for ineffectiveness of less restrictive means can only be proven by action and then failure. It cannot be proven by an assumption that it cannot work where they have not worked, Your Excellency. We have pointed out case in points like Egypt, Cairo, Your Excellency, where the same less restrictive means have been used to curb the environmental degradation, and therefore this is a tested, tried, and true mechanism, Your Excellency. With that, I pass the baton to my co-counsel to address the remainder of our rebuttal.
Your Excellencies, good evening once again. I shall be addressing the fact raised by the opposing agents conclusively. They had cited that due diligence is not a prerequisite to enact a law, and further, they claim that the Textile Waste Control and Circular Economic Act was the least restrictive means for attacking the problem from the source. However, it is still our position that one cannot sacrifice one right for another. You cannot sacrifice the right to a healthy and sustainable environment to the right to people's work. Your Excellencies, the measures proposed by the coalitions are neither a novelty nor unrealistic. Several developing states, such as Tanzania, have already adopted comparable regulatory measures. For instance, under comparative analysis, the state of Kenya requires imported second-hand clothing to meet the quality inspection standards through the Kenya Bureau of Standards, ensuring that garments are wearable and not simply textile waste. Similarly, the state of Rwanda had introduced restrictions on low-quality second-hand imports to reduce environmental harm. Having said that, Your Excellencies, that now brings us to the end of our rebuttals, and now we'd like to cede the floor back to the bench unless the bench has any other further clarifications.
Thank you, Council. And I don't know whether it is only from my end. I was requesting that you move towards Ms. Felicity so that we can have a full view of yourself. I don't know whether my brothers, you are able to see. Thank you.
No, you are right. Yes, we can see him now.
Now, my brother Judge Theory, any responses that you'd want clarified from Council for Aseka?
No, presiding judge, I have none.
Thank you. And Judge Muku?
Neither do I. Neither do I.
Thank you. Thank you, Council, for the subject. And I think now for us to retire and come up with our decision. Back to the court assistant for protocols.
If there are no further submissions, the court will retire briefly for submissions. The judges, please, you may leave the platform and you may retreat to the chambers for determination. And when they come back, they'll deliver the judgment in 10 minutes. And while you encourage, we encourage everyone to stay online, so do not leave the call as we're waiting for the judges' submission. So judges, please, you may now proceed. Thank you so much. If you may please, this honorable court is now dismissed for a few minutes.
Okay.
Hi, everybody. Thank you for your patience as the judges retreated. We thought we'd come back earlier, but it was a very close tie, and therefore the judges had to deliberate. So under the different heads that I had supplied to the participants, that will be the evaluation rubric, including knowledge of the law, application, structure and clarity, advocacy, authorities, and responsiveness to the bench. So the judges awarded, each of them individually awarded marks under the various heads for the individual participants. And then in the chambers, they have harmonized the marks and done an average. And I will let them, it is the judges who will give that determination. But my role bestowed on me by the Honorable Court is to give you participants your feedback. So I'll start with Lincoln Alexander, School of Law. Jennifer. Judges' comments is that you have splendid court etiquette. Your advocacy is also good, and you're a strong advancement candidate. On the other side, Gupta, your counterpart, the judges indicate you're a quick thinker, you can think on your feet, you have good advocacy skills, you have a good grasp of international law, you can respond to the bench intelligently and quickly, and you are also a strong advancement candidate. For Africa Nazarene University, Felicity, so indicated you have very good advocacy, you have very good understanding of international environmental law, your logical flow of thoughts are good, but you need to improve on your court etiquette. Don't treat this as a school debate. Do not refer to your counterparts as my worthy opponents. That's like a school debate. You can only say opposing counsel or counsels for the other side. Sometimes it is indicated you used heavy language, so you use simple, clear language. Your counterpart, Counsel Amani, you are very promising. You have good grasp of the law. You have a good understanding of the International Court of Justice decisions, even the previous decisions, and you've been recommended for a strong candidate for advancement. With that, honorable judges, thank you for that opportunity bestowed upon me to relay the candidates, the council's feedback as per their strength and performance. And now I'll give it back to Lady Justice Helen Omondi, presiding judge, to lead us onto the determination. Thank you.
Thank you very much, Dr. Brian. This is the outcome upon considering the arguments that were presented before this court by counsel for both parties, the case law that was referred to, and the legal principles, as well as international instruments. We make the following finding. In respect of Lincoln Alexander School, which was acting for the state of Azania, we award 67%. In respect of SECA, represented by Africa Nazarene University, we award 71%. That then means that Africa Nazarene carries the day with 71%. Thank you.
Thank you, honorable judges. That brings us to the end of the first session, the first round, wherein it has been indicated Africa Nazarene University has taken the day with 71%, and Lincoln Alexander with 67%. The next session will be on the 7th of April, 2026, which is next week on Tuesday, between GLGI, Mentors and Moot from South Africa, and Jomo Kenyatta University of Agriculture and Technology, Time 5:30 p.m., 17:30 hours East African time. And we wish you all the very best. If there is nothing else to say, we'd like to bring this session to a close. And this court is functus officio. We can see you next week on Tuesday for session 2 between Mentors and Moot South Africa and Jomo Kenyatta University of Agriculture and Technology, Kenya. Thank you very much. You are free to leave the platform.
Thank you very much indeed.